but always have a contract. Just always have a contract.
You just remember to understand the policies
Mm.
on this exception for probation, because different companies have different rules.
So in the case of summary dismissal, the employer will not give you a 1
There
month
is sufficient
notice.
notice.
They can either give you less notice or no notice at all.
So for employment matters, you should actually go to court within 3 years of termination. Yeah, they just frustrate you out of
They
the
just
job.
frustrate you for you to resign.
Yeah.
So like for example, now what I was talking about earlier in the
Yeah.
Korean international school. So instead of giving you teaching jobs or telling you to go to class, they give you slashers
jobs, yeah.
and cleaning. Hello and welcome back to the Sisters-in-Law podcast. My name is Beverlyn Mokaya and I'm here with
Aquila Mokaya. In this podcast, we'll be discussing matters law.
From talking about financial and business law, tax law, contracts, litigation, inheritance law, which is actually called the law of succession, and anything that is just matters law, we got you covered.
Remember to like, share, subscribe, and comment.
So today we're going to talk about matters employment law. Ideally, employer-employee relationship should be governed by a contract.
Yeah.
Although there are some employers who would not give you a contract because they would be scared that in case something goes wrong or they terminated you unfairly, you would go to court and stuff like that and you'll have evidence against them.
Yeah.
But if you can, insist on a contract. I realize that most people just get sacked or fired from employment and they don't know that they actually have rights. They can go to court. They can, of course, you can try to negotiate with your employer first. And then if it doesn't work, you go to court. Most people don't know about that. So today's episode is geared towards explaining to you guys what your rights in employment are. Much as it's not your job, it's not your company, you still have rights. There
because
are labor rights.
You're offering services.
Because you're offering services, and if you're based on contract, then your employer is not just supposed to wake up on one morning and say, "Oh, you're sacked. You're fired. You go home." Yeah.
But like casual laborers do not actually need contracts because for them it could be day to day or maybe week to week. So it's mostly advisable that if you have maybe month to month or year to year, depending on how you're paid, to get a contract.
Yeah. So we have an act. I think we have explained this before, but in Kenya, laws are governed through laws are put in statutes and acts. So there's an act for employment. It's called the Employment Act. And that's where most of your rights as an employee would be found. Of course, there are also employers' rights there. Yeah, but of course, today we are focusing on the employee because we're going on the route of unfair termination. Yeah, so the Employment Act provides for different ways in which an employee can be terminated from employment. Yeah. Sometimes you might find that the employer wants to restructure, or maybe they have different operational requirements. Maybe they want to close down, and that's what we call now. Maybe you find that some positions in an organization become redundant. So now that's where redundancy comes in. There's someone can lose their job through redundancy, or in other words, it's also called retrenchment. Someone can also lose their job through summary dismissal. Your boss wakes up one day and because maybe of your gross misconduct
or maybe not.
They just say, you're done, pack up your things and go. Maybe you've been absent from work, or maybe you have abused your employer. Actually, those are some of the grounds on which an employer can dismiss you summarily, like just today, without notice or with less notice. Excuse me. So for example, if your employment is periodic, like you're paid periodically, for example, every month, you'd find that for your employer to sack you or fire you, they have to give you a 1 month's notice. So in the case of summary dismissal, the employer will not give you a 1 month's notice. Yeah. They can either give you less notice or no notice at all. Yeah. And then, so of course, there's now the unfair termination, which is just the general term. And mostly that when you bring cases in court, that's the section. It's section 43, I think. That's where most people base their argument on. Yeah.
So for redundancy, it could either be legal or illegal, because there's strictly a procedure for redundancy. They must give you a notice, which is like 1 month notice. For example, if your periodic payments are like month to month, so they should give you like a 30 days notice, which is like 1 month, to inform you that we are going to downsize. We are downsizing, or we want to maybe close down. We are not able to keep up with the business environment, so we are closing down. It should be like 1 month. It should be written first.
But all notices should be written.
Yeah, with all the reasons.
Exactly. And on that note, always insist on email communication, official communication. Have those records, because in a court of law, you don't just go and say, he said, I said. It's not a matter of who said and who didn't say. It's not a matter of stories. That's what a senior manager usually says. It's not a matter of stories, because you're just telling us stories if you don't have actual paper trails or email communications to show that. So always ensure that for any communication you have with your employer, you have it in writing. Even if you talk about it verbally, follow up
with an email.
Yeah, so just say, following the conversation we had on this day, this and this, I just want to make sure that this is what you said, and things like that, so that when you're bringing a claim against your employer, you actually have something that your lawyer can work with. Yeah.
So back to redundancy. Normally, after you're given the notice, you're supposed to be given the reasons of the redundancy. So maybe if it's downsizing, if it's downsizing their organization, normally they would use a criteria on which employee is going to go, which employees we are letting go, and which employees are remaining. So maybe they could use the term of service. So maybe if you worked for 10 years, would let you go because you've worked
for long.
Or
maybe whatever they want to do, like if they want to
technology.
restructure, it's technology-wise, and people who are maybe the older generation, no offense, maybe they're not so tech savvy, so they would probably say, if you've worked here for more than 10 years, we want to go the technology way, so please, we're just gonna have to make your positions redundant, and you're going to have to just go.
Yeah, so they should also show the criteria that they were using in choosing the employees. Maybe how long they have worked. It should not be on their performance or conduct or misconduct. It should strictly be on the factors that are causing the organization to declare them redundant, downsize, or restructure.
And I think it's important to put those things in out there in the open, because you want to make sure that there's no discrimination at all. I think there's this case that I ever handled where I was even telling you about it, where it was an international school. International school. Let's work with maybe a Korean school, or because I don't want to, also put the facts out there. So it was in Kenya, and these people, like the employees in this case, the ones that we were representing, they were teachers. Yeah, it's an international school, and they were teachers. So these people come to work on a certain day, let's say like 6 months later. And actually, no, this is one of constructive dismissal, but we'll get to it. So they come to work, and their supervisor tells them to take brooms and slashers and like cleaning equipment. And so instead of teaching now, they
are
said,
told to clean.
Yeah, they're told to clean. And this is me just bringing out that point of discrimination, even at the workplace, even though it's on the other issue of constructive dismissal. So they are told to clean as opposed to teach.
Yeah.
And later on, we realized that the reason why the employer was trying to get rid of them is because of their faith, because it was an Islam-based school and they were Christians. So you see, you want to avoid a situation where there's discrimination on any basis, whether it's religion or race or anything like that. Yeah, that's just on the point of discrimination.
Back to redundancy. The employees now who have been declared redundant, they should get a severance pay, like depending on how long they have worked. So if it's 1 year, we take 15 days cumulative for that year. So if you work for 5 years, they calculate it like that, so that you go home with a package of now the severance package that you were talking about. Yeah.
And I think even at this point, it's necessary to mention that when you're looking at how someone has been terminated, how someone's employment has been terminated, you have to look at two aspects. You look at the substantive part, I'm explaining it, whether it's actually lawful in itself. You know, because sometimes unfair termination can be disguised as a redundancy.
Yeah.
You know, so you have to look at it. Is it lawful in the first place, substantially? Like, are the reasons given lawful? And then procedurally, you know, because there's the right procedure to follow in the act. So now substantially, for example, I can give an example. There's this case where there was a woman, she was a human rights director. So this woman was working for an international organization, which is also based in Kenya, and it also has other bases within Africa. And she was the human rights director. You know, you'd expect that if there's any restructuring to happen in an office, the first person to know is the HR,
Yeah.
right? It's the HR director. So can you imagine this lady? She's the HR director, and she just gets slapped with a letter of a proposed redundancy.
News on LinkedIn.
You know, so proposed redundancy. They're telling her that we are considering to restructure. I mean, usually, even when they're doing a restructuring of even the HR office, she would be the last person. She would do the restructuring, and then maybe her position would be addressed last because she has to be there. I mean, it's human resource. She's the one who's in charge of all that. So this lady got slapped with a letter from the director, now from the general director of the company, being told that we are considering to restructure the company and we will no longer need this position for this region. Yeah. So it's redundancy. Redundancy in itself is not unlawful. In itself, it's not unlawful. But then later on, this lady comes to find out that actually through LinkedIn, that there's another HR director who has been appointed in her place. So there you see that there was actually no restructuring that was happening in the first place. They were just trying to get rid of her. So in such a case, you can also bring the case before court. So now that's the substantive part, whether it's lawful. In this case, it's not lawful because strictly, like in this case, it's not lawful because redundancy, in its strict sense, it's supposed to be either the company is downsizing or restructuring, and there should be no replacement. You know,
like that office should be deleted completely.
It should be done away with completely. So this, in the first place, it's already unlawful. Yeah. So when you're bringing a case, you have to make sure that we can see, okay, it's unlawful. This is clear malice. It's clear malice. Yeah. So now, after establishing that it's unlawful in its substantive nature, now you come and look at it procedurally. Were you sent the correct letters? Yeah. Were you sent the notices on time? And actually realized, even though different companies have different redundancy policies, that's why in your company you have to read the HR policies that are there to understand when your rights are being infringed upon. Yeah. So now the procedure. There is a letter. You have to be given a notice. Like we said, all notices have to be written.
So it should be 30 days first. A notice, just as we had earlier discussed, it should be a notice that is written informing either we are restructuring, we are downsizing, or we are closing down. Like we are closing down the business. So the offices that, if it's maybe restructuring or downsizing, they should say which office is not going to be needed.
Exactly.
Like, for example,
and why?
if we say, if we do not need maybe an assistant manager, we will not be having this position because we are downsizing. If it's technological, we'll be saying maybe the people who are not tech savvy would be
done away with.
So in that letter, it should give an explanation of why we are downsizing or if we are restructuring and whatnot.
Like, for example, in this company that's in this case that I'm telling you about, their policy was that you get two letters. The first letter is the proposed redundancy. You're being told there is a possibility that your position might be redundant. So now then they called her to a meeting. You know, they call you to a meeting and they give you any alternative. Like they ask you if you can fill up any alternative role. Like, for example, we have this role that is vacant, although that's just, I feel like it's just mostly on paper, but they don't really so that they look like they have done the correct thing.
They have gone through the right procedure.
Yeah, so they have to allow you to take up any alternative positions, if any. Yeah. And then now after that, now they sent her the actual redundancy, like the actual now termination notice, you know, now that the 30 days one, they told her, okay, now because we gave you the first letter, we have had these discussions, and this is what we are offering you now, the benefits that you're going to talk about, the severance pay and stuff like that. So now we have given you the actual notice of termination, now the 1 month's notice. And then also before that, like if someone is part of a union, if someone is part of a trade union, you have to inform their union.
Yeah, and the labor office also.
Yeah, and if they're not part of a union, you have to inform the labor office of your intended redundancy. Yeah.
Now, just as we had earlier discussed, they should tell you why they're letting you go on what basis, which should not be anything that is discriminatory or whatnot. So if you just feel or you have evidence to show that it could be unfair termination coined as redundancy, this could be the best area to look at. If, for example, analyzing, maybe I have been fired because of my tribe, maybe my race, my faith, or whatnot, just under discrimination.
Like we can tie that up, like just as I said initially, the substantive part, whether in itself it's lawful, and the procedure. So if you don't get them on the substantive part, you could still get them on the procedure. So I think we've dealt with redundancy. The next one would be now, what is the right termination like procedure? You know, because someone is allowed to terminate. You're not supposed to work with them, you know, till kingdom come. So like an employer is allowed to terminate your employment, or your employment contract. There's a right way to do it.
Actually, they have the right to terminate.
Exactly. Actually, they do. So what is the right termination procedure?
So for normally, termination is normally on basis of maybe gross misconduct. So maybe you've been doing something continuously. Okay, I almost broke out laughing because I have an example that is funny in my mind. Anyway, so normally termination is majorly on gross misconduct, or maybe just going against the company policies. So normally, if you have been found to be conducting yourself grossly,
it's okay.
You're supposed to be given a warning letter first to be warned about your conduct. You cannot just maybe sleep if you're a watchman. You cannot just sleep on duty today, then tomorrow you're okay. Then your duties, your services are terminated immediately. No, you're supposed to be given warning letters. So it is variant depending with the company. Others would say maybe three warning letters, or maybe 2, or maybe 1. But as long as they have given you a warning letter, and then now you go to the next step, you're given a notice to show cause. So when you're given a notice to show cause, you can go with maybe an advocate, if you can get one, or maybe any representative, or even a third party who you can call as a witness.
One of your other employees.
Yes.
Yeah.
So you
and
go
it's a must
for you to be with somebody.
Yes.
Yeah. So you go to show cause why it should not be terminated, which is normally just a procedure. So you go, present your case. The employer presents their case. You present your case. You are heard because you have a right to be heard, provided for in the Constitution. So you are heard. Your side is also heard, and then normally you are told to come to give a response in writing. Now that's where the importance of an advocate comes in, where they could now respond on your behalf. But remember, when they were conducting the hearing, if you had a witness, even if it's your friend or a colleague or just anybody who witnessed every other thing that was happening that amounted to this, you being given a notice to show cause, they're supposed to come give their witnesses, their statements, and then you respond, like you respond to the allegations. You're given like a period of time to respond, and then now the employer, the company, can now give you the termination letter. Remember, all these things are in writing, from the warning to the notice to show cause to the response and to now the termination. But now when you're given that termination letter, you're given 14 days to appeal, which is compulsory. Yeah. Nimesahau kwenda mbele.
Yeah, so so in the event that you are terminated and your employer did not follow any of these steps, for example, they didn't give you a chance to bring someone with you in the meeting where you're supposed to be heard on whether or not you should be terminated, that's also like it could be a ground for unfair termination.
Yes.
If they don't allow you even an opportunity to be heard. Like they just come today and tell you, hey, pack up your things and go. You stole XYZ, you know?
Yeah.
It's also a ground for wrongful termination. So all these things, this is part of the procedure. I think I keep going back to that structure because it's very important to know that procedure is separate from whether it's lawful. Because it could be that it's true anyway you stole, yeah, but you've not been given a right to be heard, so they cannot condemn you unheard. Yeah. So if you come and say I didn't steal and they didn't give me a chance to be heard, that's a ground, like you can make a good case out of that.
Yeah. So there's this case that I was actually handling for, it was a watchman. So this watchman, you know, as a watchman, you've been employed to watch, ideally. That's what you've been employed to do.
To watch at night and during the
watch
day.
at night.
Okay,
So,
to keep watch.
So this guy, he dozed off. And then he was caught dozing off the first night. Like the first night he was dozing off, he was caught. And the CCTV cameras were blurry and whatnot. So he was not given a warning
this is
later.
that pro bono case.
Yes.
Okay.
So he was not given any warning later. He was just caught today, dozing off tonight. He was told notice to show cause was given the next day. So there was no period where he had ever been warned of dozing off at work. So that one is procedurally defective. So he can sue. He actually sued for unfair termination. Yeah. So for employment matters, you should actually go to court within 3 years of termination. That is the limitation of time for employment matters. But also we had not mentioned that there's an exception to unfair termination, which is if you are on probation, you can be given 7 days notice, or not, because you are still on probation. Yeah.
Again, it always depends on your contract. There, of course, your contract has to be subject to now the act and the provisions of the law.
Yeah.
But always have a contract. Just always have a contract.
Yeah.
Because that's already a written thing that someone can work with. That your employer breached this, this clause of the contract and stuff like that, and you'd be able to go to court. And of course, we'll talk about how to start this case, and at the end of the video.
Also, just remember to understand the policies on this exception for probation, because different companies have different rules. That if we give you 3 months probation, when it's over, when does the contract start running officially?
Yeah.
And if you're being retained or not, how are you supposed to be told? Yeah.
Ideally, by the way, it should always be written, and then the contracts should be different. Like a probationary contract should be different
from your employment
contract, because now after probation you have to be confirmed or not.
Yeah. Now, which is now the 7 days.
Yeah.
And you cannot sue for unfair termination.
Exactly.
Yeah.
Now there's something called constructive dismissal. This is where your employer makes it hard for you to stay.
Yeah, they just frustrate you.
They just frustrate you for you to resign. Yeah. So, like for example, now what I was talking about earlier in the Korean international school. So instead of giving you teaching jobs or telling you to go to class, they give you slashers and cleaning whatever detergent for you to actually clean around the school, around the students you used to teach.
Wow, that's hard.
Yeah. So I have another example. There's this lady. She's a family woman. She was working for a company, I think in Kenya. So now, this company, when this company was done with her, this is what the company started doing. They allowed her to work, let's say, for example, in Nairobi for 1 month. After 1 month, they transfer her, to Kajiado for another month. After 1 month, they transfer her to, let's say, Lodwar,
Yeah.
After another month, they take her to Coast. And this is a family woman.
Yeah.
I mean, this is just clear that they want to do away with you, So this lady, it's actually an already determined case. This lady brought the case in court under that doctrine, the doctrine of constructive dismissal, where your employer makes it so hard for you to keep working with them for you to resign. So when she brought that case in court, she actually won the case, and she got her benefits, like which we'll talk about later.
Yeah.
What's like how the court can compensate you and stuff like that. So yeah, if your employer does anything like that, they make it hard for you to work,
just stay at
to stay there so that you can resign. That's how they try to cheat their way,
into
so that it looks like you are the one who resigned, and yet they didn't want you there in the first place. Maybe your employer just decides to not pay you. you're working, you go to work,
but
they just don't pay you.
But
and
also,
they're paying everyone else.
It's also important that the employee now ties the resignation to these frustrations.
Exactly.
So they'll say, I am resigning because I've been moved from maybe Lodwar to Embu to Meru to Nairobi within 4 months, and it's not so good for me. Ensure that you tie.
And actually, even before you, like when you start seeing such things, just write them emails. Write your employer an email. Tell them, oh, I'm not comfortable with this. Can we? And then, of course, maybe they'll respond or not. But just make sure you have a paper trail where when you're going to court, you can actually justify that. This was constructive dismissal. Yes. I was supposed to be a teacher. Why are you making me do cleaning jobs? Yeah,
that makes sense.
Yeah, so that's also another way that employers would try to terminate you unfairly. So that, and make it look like you're the one who was done working with them, and you just quit.
Yeah.
I think we've been mentioning about how you can go to court. Even before you go to court, usually, like, there's something we usually do. We do a demand letter to your employer when you come to us as lawyers, right?
Yeah.
So we write them a letter and tell them, oh, you have unfairly terminated so and so, and we are giving you, let's say, 14 days to either reinstate, but anyway, who would want to be reinstated? Yeah. Or pay this compensation. Now you list all those remedies that you're about to talk about. And if you don't respond within 14 days, we go to court. Yeah.
So if, for example, a contract was, the contract was maybe for 3 years, let's say, and you are unfairly terminated in the first year. I have another example. You are fairly terminated in the first year. We can calculate the remaining 24 months. Now we compute it as the salary that you were supposed to have been receiving.
Yes.
Because the contract says that you are going to work with us for 3 years, but now we have unlawfully terminated your employment. So we can always compute the remaining number of months that you were supposed to work with us, and then now we put it in the demand letter also. So maybe we go now for compensation for your mental turmoil. Maybe you are unable to pay school fees and whatnot, just whatever that arose out of the termination, which is normally negotiated. It's always negotiable. So as an employee, you would want to just imagine the amount. Like maybe if you were hit, we could say maybe 1 million or 2, just like that.
So, like, yeah, the court can give you damages, although the courts will rarely give you. There's something called, whether you have to educate them. There's something called general damages and something called special damages. Yeah. So special damages are those ones that you can compute. Like, you can say specifically,
I went to
hospital and these are my receipts. So you owe me XYZ, right?
Specifically
pleaded, and you have to attach receipts. That's why we insist, just keep records of everything. You just never know. Yeah. And then our general damages is where the court usually decides, like, based on what happened previously in other cases. Like, for example, maybe mtu akiumia, like if someone gets a fracture, and for the pain and suffering, now the court will come and determine, oh, because this person has suffered pain and suffering, or maybe she was supposed to, let's say, maybe she was an engineer with KPLC and she cannot do all those stuff that she used to do before. So now you compensate her for loss of income and things like that. So the court usually determines, like, so that's general damages. You can't come with receipts and say,
this is the amount of pain I went through, or something.
This is the amount of pain I went through and all suffering I went through. So, like, you'll find mostly in contracts, the court rarely gives general damages, unless maybe you bring it as a case in terms of, let's say there's this case, for example, where our clients had gone to DRC to work there. Like, someone had told them, there's an opportunity in DRC. You guys come and work with us. And they go there. At that time, there were clashes. Like, there were civil wars in that area. And they got there. They're not given accommodation. They had to sneak around. They didn't even have like the proper documentation to be able to walk around. They literally suffered emotional and mental turmoil, and also the contract did not work and they were not being paid. So now you see, in such a case, you would bring, okay, we were not paid for this amount of time, and also we underwent like degrading treatment. So that way, maybe in such cases, the court will be able to give you those extra damages. But it's not easy for the court to give you general damages, in contracts.
Also, if you are given if you are not given notice, normally in the demand letter, you'd also include the 1 month if you are being paid month to month. So you'd include the 1 month pay in lieu of notice because you were not paid. Just like an employee, if you are resigning from a job and you did not give the sufficient notice, which is now the periodic, according to how you're being paid, maybe month to month. If you did not give the 1 month notice, you forfeit the salary that you were supposed to get in that month that you did not give the notice here. So you can also be given the 1 month pay, and also you could if you are given notice, if you are not. And then also after, if we had given you had a contract would compute, and that would be in form of compensation. Yeah.
And that's in the event that you actually had a fixed term contract.
Yes.
Like if your contract specified 3 years and you worked for 1 year, and now you could say that you have expectation to get the salary of the rest of the contract. Now you put that as one of the remedies. But in the event that there is no fixed term contract, mostly the court would give you 12 months compensation, or like the court has leeway, discretion to give you even 7 months, kwenye niliona 7 months.
And then also the other thing you can get is maybe reinstatement. You can be called back to work. But now what most people do, they get the reinstatement and then now they go and resign officially, so that they do not have the, oh, you are fired from some place. There's a client that I dealt with some time back who was working in a big government agency just here in Kenya. So she was given a government car, of course, because she was in one of the top positions. So one day, just during the June mandamanos at the time, her car was turned outside by other people. Like when she was just leaving work, it was one of those days that there was mandamano, so the car was turned outside, and she was fired because of that because the car was turned. But you see, she had not been given any notice of why she was being fired. Now she was being told in the termination letter that we're firing you because you did not take care of company property. Yeah. So what she was seeking as remedies was reinstatement, but just because the environment was hostile, she was going to now resign. If she's reinstated, now she would resign and apply in a different agency, because the agency is like a serious agency in the country.
Yeah, actually one of the other things that you usually ask for is you demand for a recommendation letter.
Oh,
yeah.
Wow.
There are a couple of cases where we've done, like in the claim now, when you're asking for the remedies or the reliefs, you just say, let's say for example 12 months compensation, or you can do 17 months just because you can, and then the court will decide
and give you maybe
12. And then we asked for, this was the one for redundancy now. We asked for severance pay. We asked for a certificate of service.
Oh yeah.
And then we asked for a recommendation letter.
Okay.
Exactly. Yeah, and actually, so of course you first of all start with, like make like the court should make a declaration that you were unfairly terminated.
Yes.
And then you ask for those remedies, and then you just put general damages. Actually, this person put also psychological support, because she had receipts whereby, she had been living in, I think, Kilimani. Yeah.
Oh no.
Yeah, and now the only reason she had moved there is because
she was working
here and the salary could support.
good.
Yeah.
Oh no.
So she was like, no, now I need to look for a new place. You have just terminated my employment right now. I don't even have a place to go to. My kids, I was supporting my kids. They were going to these big schools. I don't have the money, so I had to seek therapy.
Now I want to talk about a hypothetical case. Let's say, for example, person A is employed as a field officer. So he goes to the field because now that's his JD. And then maybe he's beaten in the field, like he's harmed. And then now he goes to hospital. And in his contract, they had provided that this office is going to be paying for the medical bill. So they have an insurance in the office. But now, when this person A is hurt, goes to hospital, but now the company does not pay for the hospital bills. So now he ends up paying himself. So he pays
paying for the bills.
Yeah, the hospital bills. But by the time he's recovering, when he comes out, he goes on Facebook, and then he finds that somebody has already been appointed as a field officer to replace him. So he would want to ask her, no, okay, why was I fired, and why am I finding it out on Facebook? He goes back to his account. He realizes that the previous month he had not been paid. when he inquires from his colleagues, the colleagues have already been paid the previous month's salary. So he now goes physically to the office to inquire. Why is he just finding out on Facebook, and why has his salary not
been paid, and why is there someone else
in his position? And then also, why didn't the medical bill be cleared by the company? Because it's part of their contract. So he goes. When he gets there, he's beaten. So he's not even given a chance to see maybe the manager or anybody. So he's beaten on top of being fired on Facebook. So he's hurt, he leaves. So what he wanted, or what he wants, is, for example, I want a recommendation letter, just as you said, and that certificate of service to allow me, because if I'm working with a government agency and I write them as my referees, they'd always be asked. And now I cannot get another job on that basis. So now this guy, what would this guy do?
So, like, for example, they would come to you and you do a demand letter. Of course, it's an action in futility.
Yes,
but it's just usually, if they already beat you up and stuff, it means they don't want you there. So you do a demand letter. Tell them, we act for person A. You said person A.
Yes.
We asked for person A in this case. You fired them on this day, maybe through Facebook, or they came and found that someone else had replaced them. Like, you have to ensure that there is actually termination. Like, we want to establish the facts around the termination of the employment of this person.
Yes.
So our instructions, therefore, are to demand from you either reinstatement. You just say it, but I mean, of course, like we said, or compensation in the following terms. So, like, for example, you'd say, if it was, let's say it was a 3-year contract, as we said initially. So you say maybe he works for a year. So you ask for, and he was getting, let's just work with 10,000 salary. For ease of computation. So 10,000 times 24, that's 240,000. So you would say you want compensation of 240,000. And then let's say they were being paid $10,000 in the spirit of, So you say that, like, compensation of $240, right? And then let's say you ask for a certificate of service, like we said. In this case, you can say general damages because he was beaten. Right? Maybe he went to hospital, and then, of course, now medical expenses. You have to get.
So he was beaten twice because he was beaten first in the field, and then now he was beaten in the office. So you'd ask for compensation for payment of the first medical bill because you were on duty. And then now he'll ask for a further compensation for this second beating. But also ensure that you have an OB to show the assault, the assault bit and the extent to which you are assaulted. If they maybe cut your ear.
Why would you say cut your ear?
So if maybe they hurt you, maybe they hurt your leg or something, so that we see the extent. Or maybe you would never work again, you'd never work again. So we would want to see the extent.
Actually, now that's where general damages would come in. So that's also something that you could ask for. So that's the demand letter part. Like I said, tell them 14 days. If you don't respond within 14 days, then we will be forced to go to court. All that legal jargon that we put there. But in short, it's just that we'll be forced to go to court. So after 14 days, now, of course, after paying, after the client has paid you some deposit of, like, some amount in deposit, you put in a claim. Let's just call it a claim for ease of understanding. But it's a memorandum of claim. Nowadays, if the salary of this person, the compensation or the release that you're asking for is below the 20 million, you can usually go to the lower courts. Kitambo, like, in the past,
it used to be employment.
It used to be you have to go to the Employment and Labor Relations Court, but right now you can start from the lower courts. So you go to the lower court, for example, if it's below 20 million, but if it's above, you go to the Employment and Labor Relations Court. It's a high court. It has the status of a high court. So now you go to court, you put the claim in court, of course, now based on all the things that we have discussed. Is it lawful substantially? Is it lawful procedurally? So, of course, because we are the lawyers, you're saying it's not lawful. And make sure you have come with the documentation, the emails,
from
the letters, or evidence of none of it.
So I've just realized that we forgot to discuss if a company has the complaints, a complaining procedure. For example, back again to understand the policies of the company,
your organization.
Yes. So if even if they have followed these rules of the like this just general, the ones that are provided for in law, and they have not followed the procedure in their policies, it can be procedurally defective.
Exactly.
Yes.
Yeah. So I don't know. Most people don't like to read.
Yeah.
And most people don't like to read the company policies, but it's just good for you to know. It's good for you to insist on getting the policy handbooks and understand how things work in the event that there's termination, and read, and then for you to know whether you are
you have grounds or something like
exactly.
that. Yes.
So I think I was talking about you bring the claim. We can go back to the procedure now. Like you bring the claim in court, either the ELRC, the Employment and Labor Relations Court, which is the High Court, or the lower court, if based on how it's 20 million and above or 20 million and below. And then after that, now we serve the other party. We serve your employer. Maybe they come to court, they enter appearance, they come into court to defend their case. Yeah, they put in a defense, and then this can take close to 3 months.
Yeah.
For example, for example, now of course you put in the claim. It's good for us to give them timelines.
Yes.
You put in the claim today. There's something called summons. You take out summons. So now those summons can you are supposed to serve those summons within a certain period of time. So if your wakili or if your advocate is very active, they should be able to serve it immediately. Like you take the summons, you serve them immediately on the other party. That's now your employer. The employer usually has I think is it 10 days
to enter appearance?
I think it's 15 days. I don't know. I think for us we do the plaintiff's case. So I usually just so there's a period in the memorandum of in the summons whereby the employer is supposed to put in a memorandum of appearance. I think it's 10 to 15 days. Yeah. And then after that, now they are supposed to put in a defense within 14 days after putting in their memorandum of appearance. So after putting in their defense, now you go to court. The court has to determine that everybody has filed their documents correctly. Don't think it's like the next day. It can be a month later or 2. I mean, by the time there's a case that we got at 2025 May 2025 date in August. Because our courts are just like that. Like the delay is crazy. So don't expect that you might get it immediately. Just expect that there are going to be delays and stuff like that. Let's just work with 2 months, 3 months. So the delays in court are very common. Like for example, I mean, how do you go to court in August 2024 and then you're told that the next date you're going to come back? It's May 2025. That's almost a year later. Yeah. So just expect that the delays in court are natural. Yeah. So you come back to court, ensure that everybody has filed their documents correctly, and then now the hearing can start. So you do the hearings, and then now you do your submissions, which is just every party explaining their case, and then now the court will give a judgment. If you don't like the judgment, you can appeal. If your employer does not like the judgment, they can appeal. Yeah.
So when a case has already been determined and the case has been in your favor, for example, and you're compensated and awarded maybe damages, and your employer fails to pay and just refuses to pay just because they can, you can always execute against them. Like there are lawful ways of executing against them, like attaching and sell. So you can attach their property. For example, if it's company property, which you can sell and get the amount of money that you have been awarded in court, and then also you can now institute garnishee proceedings.
Where you said attaching and sell, that's where the auctioneers come in. We are friends with the auctioneers. So that an auctioneer would come and then they go and attach their property and sell, and then your client gets their money, and the auctioneer is able to get the auctioneering fees from that person, now from the employer. And then now garnishee means that, let's say for example your employer has money in bank account A in KCB, right, and you're aware of it, you can attach their property. Or you can attach that bank account and ensure that the bank pays you. Of course, it's also another long process which you could talk about in another video. Because it's important for people to know. You can get a judgment from court, but it's not a guarantee that you'll get your money. So that's why you have to bring in auctioneers, you have to bring in banks, you have to bring in
other things that would help you get the judgment.
Yeah. So I think that's it for today.
Yeah, that's it for today. If you enjoyed the video, kindly let us know through liking, sharing with your friends, and even subscribing. Also, if you have any questions, you can post them down below in the comment section. And also, if you have areas that you want us to talk about, please let us know.
Thank you for watching. Bye.
Bye.